you see this corn rake sticking out of her.
Yes.
You have your phone on you.
Yes.
You don't call 911 right away.
No.
You immediately try to pick her up.
No. I looked and I turned her face towards me to see if she was breathing or alive. And I was asking her name, Amy.
Then she's not responsive at all.
No.
And that rake is still sticking out of her.
Yes.
Now,
welcome to Law and Crime Now, everybody. I'm Jesse Weber, and that is Todd Mullis, the man who was convicted by an Iowa jury of murdering his wife, Amy, with a corn rake. Prosecutors had explained how Amy and Todd's marriage was on the rocks, how she was having an affair. He was afraid if a divorce ensued, he might lose a portion of the family farm, so he ended up killing her. But not only that, he made it so that his son would actually discover the mother's body. And this was an interesting case where you start off with Mullis first claiming that this was some sort of accident with the rake, and then later on during trial, his very own defense put forward that maybe someone else killed Amy. Well, now Mullis has his official sentencing. It's coming up after being delayed 4 times, including because of the COVID-19 pandemic, and he faces life in prison without the possibility of parole. Let's break it down right now. I'm joined by juvenile judge and trial attorney Judge Ashley Willcott, as well as forensic death investigator from Jacksonville State University, Joseph Scott Morgan. I want to thank you both for coming on. Judge, let me start with you. What can we expect from an upcoming sentencing for Todd Mullis?
Well, a couple of things. First, it's going to be interesting to see, Jesse. It's my understanding there may be a renewed motion for a new trial that's going to be addressed on that date. We'll have to wait and see. But the sentencing hearing itself, one of the most crucial pieces of that I would expect are the victim impact statements, because regardless of the fact that he faces the mandatory life in prison without parole, the victims still get to make those statements, and I expect we're going to hear them in this case.
So, Joseph, we're going to get to his appeal in a second, but, this theory that first was going through that maybe it was an accident. Based upon the evidence, why does that not work? Why does this accident idea not work in this case?
Oh, well, because there are too many defects or holes in her back to marry up with this scenario. We covered this on the air together, Jesse, at the time. And for those that don't know, a corn rake has what are referred to as tines. They're these multiple forks, and they're curved like this. And when she fell, allegedly, it stuck in her back. But the problem is that the trajectory or the angle on these things, you've got multiple holes that match up. There's more than 4 puncture wounds in her back. So not only did she get struck from the rear one time, somebody actually moved and readjusted the rake and struck her again. I would imagine the first one was to knock her down. The second one was the fatal blow while she was on the ground and killed her at that point. It's an empirical impossibility for her to have fallen on the thing twice.
Yeah, it's absolutely awful when you think about that. But, Todd Mullis went on the stand during his trial and defended himself, said he had nothing to do with this, has no idea who would have killed Amy or what happened. But under cross-examination, he faced some tough questions, including the 911 phone call. So apparently, when he called 911, the prosecution thought that he might have been uttering something very specific to his wife, who he was attempting to resuscitate. So listen to this back and forth between the prosecution and Todd Mullis when he was on the stand about what exactly he was saying.
now Todd, here I'm gonna play you the part where you're doing the chest compressions, and I'm just gonna ask that you listen in between the chest compressions, okay? Now, Chad, did you just hear that whisper at the end of that?
Yes.
And what did you whisper?
I couldn't hear it.
Okay, I'm gonna play it again. Todd, do you whisper cheating whore right there?
No.
So you don't remember what you whispered?
No.
Okay, I'm gonna play another clip for you. Do you know what you whispered there?
No.
Did you hear that? So I'm going to play that part one more time. The first clip is 6:53 of that second tape, and this second one is right at 0700. Just try to listen really closely. I just want to know if you remember what you said. Right there, do you say "go to hell, cheating whore"?
No.
So you don't hear that?
No.
You didn't hear at 6:53 cheating whore. You didn't hear that.
I didn't hear that word.
And it's right at that, after you hear a ping, you don't hear "go to hell, cheating whore."
No.
All right, Judge, that was a big moment there, and I have to imagine that during his fight for a new trial and his appeal, he might argue that the prosecutors engaged in some unfair tactics there by suggesting that he did say that. What do you make of that back and forth?
Well, I do think that the prosecution really went, he said, I couldn't understand what was on the tape. And so instead of stopping there, they say, oh, well, didn't it say this? But I think this is more likely to not help him. And that is, first they say, did you say this? No. So you don't remember what you said? No. Those two answers just don't jive to me. I think that I think this is more hurtful to him than it is to the prosecution.
Yeah, and Joseph, it goes to the prosecution's overall theory. I mean, who else would have killed Amy? You couple what he said on the tape, or allegedly said on the tape, with the internet searches, which seemed to suggest somebody who was very interested in harming his wife and what the consequences would be. The searches that he allegedly conducted seem to support that. On top of the fact that, this is a rural area and the difficulty of someone else jumping in and jumping out. Now, having said that, that's me talking. Your perspective, looking at the crime scene, looking at all of the physical evidence, is it possible someone else could have committed this crime in this way?
Well, I suppose anything's within the realm of possibility, but this is a weapon of convenience, Jesse, that was used. This is something that's within reach. It facilitates an ends to a means. And it's not something, if you're some killer that's stalking the countryside in rural Iowa among the cornfields, I don't think you're going to show up armed with a corn rake or think, wow, I'll just show up and grab their corn rake and kill somebody. You're going to show up with something else and be more prepared. That's why it gives me pause.
Yeah, that's a really good point. I mean, you wouldn't have carried that with you. It almost seemed like a crime of passion in a way. It's such an heat-fueled way to kill someone. Having said that, we can't forget what the first story was, that he said this was an accident, and making it look like your mother had an accident in the shed while she was recovering out of surgery. She shouldn't have been carrying things. Well, that brings us again to Todd and Amy's son, who took the stand and explained what he saw. Really traumatic. So just listen very carefully to what he had to say when he took the stand.
And would it be fair to say that this was a very traumatic experience for you?
Yes.
You indicated earlier that you actually felt like you almost were going to pass out when you found your mom.
Yes.
And obviously, what were you feeling after you found your mom?
I just kind of freaked out, and I was, my anxiety level was 0 to 100 in about a split second.
Now, you spoke to police, sheriff, that day at the hospital, right?
Yes.
And they asked you a little bit about what happened that day.
Yes.
And you told them at that time that you were with your dad the whole time.
Yes.
You also talked to Scott Rieger from the Department of Criminal Investigations. He came to your school a few days later and talked to you.
Yes.
And he also asked you if you were with your dad the whole time.
Yes.
And you said yes.
Yes.
And lastly, you also talked to a forensic interviewer at the Child Protection Services a couple months after this happened. Is that right?
Yeah.
And you also told that interviewer that you were with your dad the whole time.
Yes.
But what you're telling us today and what you told us at the deposition is that there was a period of time that you were not with your dad.
Yes.
So, Judge, we're dealing with a situation where the son, his testimony really helped the prosecution ultimately gain that conviction against the father. I have to wonder in a sentencing hearing, is the son going to speak? What would he say? How would that look? What do you think?
And that is the first question I thought to myself when I was looking at victim impact statements and who might be speaking in this case. First of all, remember, he was, I think, 12, if I have it right. That's my memory, my recollection is. And to go through this, he found his mother. Remember, he was the one who found her on the ground and was the first on the scene. And after finding her, then she's deceased. Then he has to testify. And honestly, then it makes clear that however he was instructed to do it or whether he just chose to do it, he gave two different statements. So he's gone through all kinds of trauma up until this point. It's hard to imagine that someone at that young age would choose to make a victim impact statement. On the other hand, he's some years older now. It may be his opportunity for closure to really say whatever it is. And if he does speak, we don't know which way he's going to go, right? Is he going to mourn the loss of his mother and say, I can't believe he did it? Or rather, is he going to say, listen, I lost one parent. I don't want to lose this parent too.
Yeah, and it's no easy answer. I'm curious to see if he speaks, if Todd Mullis says something, inconsistent with trying to say, hey, I didn't do this. I'm going to keep fighting this. There's a large support group for him as well online who people believe this was an accident and that perhaps his attorney was a bit negligent by saying this was a murder. Maybe you should have stuck with this idea of an accident and have the experts battle it out of whether or not this was a killing or an accident, not say someone else did it. Because as we just went through, that's such a weak argument. Who else would have done it? Who else would have had the opportunity? Who else would have had the means to do it? But yeah, we are going to cover this sentencing hearing on Law&Crime, and we'll follow it. Now, having said that, when we come back, we have an update for you, huge update in the Brianna Taylor case. We'll be back. Welcome back, everybody. We turn now to Brianna Taylor, the Louisville EMT who was killed in her own apartment during a police raid. Many people are wondering if they are going to get an update in this case, more specifically, whether or not any of the officers involved will be criminally charged, specifically because no drugs or paraphernalia were found in Taylor's apartment, how the police obtained their warrant, and there was an issue if the officers identified themselves before barging in. Now, Kentucky Attorney General Daniel Cameron was asked all about this on Face the Nation, and he made a pretty big announcement. Watch.
And I can announce to you today, as part of those efforts early this week, we have received that ballistics report. Now, again, that is a critical piece of this investigation. It's not the end-all, be-all. There's still some witness testimony and interviews that have to be conducted, but we do have that ballistics report. We will be meeting with the FBI at the beginning of this upcoming week to have a painstaking review of that information, and that will help us in the analysis that needs to be undertaken before we can get to final steps. But just, again, like Representative Deming said, right, we need a thorough and fair investigation, and I wholeheartedly agree with that sentiment.
Joseph, let me turn it over to you. We have this ballistics report. What does it tell them? What does it tell the prosecutors? What does it tell investigators? But maybe also more importantly, what does it not say? Because clearly he said it's not the end all be all. They still have to do witness interviews and testimony. So what does it say and what does it not say, Joseph?
Well, I think he's not saying a lot here. He might very well have a ballistics report from the FBI lab, but my question to that would be, well, is it a lab exam that merely examined the recovered projectiles? Okay. Or is it a lab exam that examined the recovered projectiles as well as their trajectories? And that is, did the FBI physically go out to the scene with their evidence response team and reconstruct the scene using lasers and lines? You pull lines at these things to show the attitude of the shooter versus the victim. Now, those are two completely separate things, but sometimes they can be referred to as ballistic reports. If the FBI team is involved in this, along with the state police in Kentucky, then yeah, this is pretty significant. I don't know how significant it is relative to just simply a ballistics report generated in a crime lab where they're test firing weapons.
So let me just follow up with you, Joseph, on that. Again, I guess the question is, we can't forget that Kenneth Walker, who was Taylor's boyfriend, He opened fire on the police thinking that there was an intruder. He didn't know what was going on. He was at one point charged with attempted murder, and that charge was dropped. But here, are they trying to determine who fired first? We talk about questions of use of force or excessive force. What does the ballistics report, how does that help in a certain way? And you mentioned the trajectories in that, but what more of the story does it tell us that we don't know at this point?
Well, it's very difficult to determine most of the time who fired first. However, what they can do is listen, every single weapon out there has a specific ballistic fingerprint. All right. It doesn't even matter if it's made by the same manufacturer, Glock, Smith and Wesson, SIG. It doesn't matter. Each individual weapon will have its own distinctive markings that it leaves behind on the bullets. So, with that said, if he is using one weapon, okay, and the police have another, they're going to try to separate out these rounds to make sure that the police weren't just wild firing in the room. All right. So they're going to tie these back, each and every weapon used in this incident.
That's a good point, and I'm curious to see where that goes because we're getting more information from this case. And Judge, I want to turn it over to you. There's been a leaked LMPD memo from the police department. Apparently, it was finalized after Taylor's shooting, and it seems to provide a rationale or even a justification for why the officers entered into the apartment. Apparently, it says that Taylor knew the suspect, Jamarcus Glover, back in 2016. Remember, that's who they were ultimately trying to apprehend, or they were ultimately trying to find more information about, Jamarcus Glover. Apparently, Taylor had posted his bond in 2017. He called her 3 times from jail in 2020. She had said to him over the phone at one point that he is creating a bad environment for her with all this law enforcement intention. He used her phone number as a contact number, clearly establishing that there's some sort of connection between the two. But this memo didn't get into the specifics of use of force. There are critics, specifically from the attorneys representing Taylor's family, who say this is a one-sided memo, and it shows the police are trying to protect themselves. How do you view this information?
Well, you need an unbiased investigation to gather all of the information. So certainly this does provide some of the picture. It does provide a reason why law enforcement had cause to enter the home, right? But it doesn't provide information about the force used, as you said, whether or not they announced themselves, how the shooting started, why the shooting started, were they in fear of their life? I mean, I don't think there's any justification for her being shot this many times. And so that's why we need the complete, full investigation to put in context the fact that, bottom line, it sounds like the police probably had cause to enter the home. What happened next is the problem or the issue that has to be investigated.
Well, we also, you heard Cameron mention witness testimony, witness interviews. Let's go back to Kenneth Walker, Brianna Taylor's boyfriend. Again, in that apartment, opened fire. Here's what he had to say when he heard the knocking at the door.
So you were just laying in bed?
Watching the movie.
So you was in your room watching?
In both of the rooms. She had actually just dozed off, probably like 10 minutes before. So laying there, laying on her, watching the movie by myself. It was a loud bang at the door. Both of us are not decent. Can't even think of the word right now. You know, we're home. We're in the bed. It's 12 at night. Our day is over. So it's a loud bang at the door. She pops up out of her sleep. It scared her to death. Me too. Like, who is that? I was honestly thinking it was because we've been on and off together, whatever, for like 7 years or whatever. So it was a guy that she was messing with or whatever throughout that time, you know. And he popped up over there once before while I was there like a couple months ago. So that's what I thought was going on.
And look, in the end, I think I've said this before, people just want a conclusion to this investigation and answer one way or another. Will the officers be charged? And if not, why? We'll wait and see what happens. But people still want answers on the next case. Ghislaine Maxwell, Jeffrey Epstein's former girlfriend, associate, whatever you want to call her. She's in jail on federal sex crimes and perjury charges for her role in a purported sex trafficking ring. And apparently, her attorneys have been able to visit her at the federal detention center. Now, why is that big? because she would be the first person to have a jail visit from her attorneys at a federal jail in New York since the pandemic happened. And there have been many attorneys who have criticized this, saying, you know, their clients, their detainees haven't had the opportunity to have these meetings with their attorneys. So, Judge, I turn it over to you. You know, there's an article on lawandcrime.com about this. We had an opportunity to speak to some of the attorneys who were very critical of this. It seems unfair treatment. The wealthy, her, seem to get this preferential treatment to have a meeting with her attorneys. How do you, what do you think about that?
First of all, I love the article on Law and Crime. But number two, you have to apply it universally, right? As a court, as a judge, that's part of the responsibility, that you cannot apply things with regard to a person's status, race, gender, but rather universally. And if this federal penitentiary is not allowing other attorneys who would agree to come in person, waive any of the fear of the corona, and do it with the right safety precautions required, then there's no reason in my mind they should be treated any differently.
Well, Judge, the Bureau of Prisons says they're going to make case-by-case accommodations in light of this. And I mean, let's not forget, Ghislaine Maxwell was able to meet with her attorneys for 3 hours, and originally the MDC said that they would only allow attorneys to visit for 1 hour. We have about 20 seconds left. What do you make of that response?
Case by case means more than one. I've only heard of one so far. That's the problem in my mind.
And people who are critical of this, you know, looked at Epstein, said he got special treatment. Looking at her, she got special treatment. Doesn't really help the case on the other side. But we'll see where this goes, and maybe it'll allow other clients to have an opportunity to speak with their attorneys. Joseph, Judge, thank you both for coming on. Everyone out there, thanks for joining us here on Law and Crime Now. Until next time, be safe.